My name is Michael Scherini. I'm the principal lawyer of Scherini Lawyers. I've got with me today Mr. Rodrigo Haddad. He's a specialist as well in commercial litigation and in particular insolvency matters. I've known him for a long time. Since university, he's been a good friend of mine and a close colleague that shares a lot of good stories and a lot of good experience and wisdom with me. And I'd just like to say thank you so much for joining today, Rodrigo. How are you doing?
Hello, Michael. Thank you for having me. It's good to be here.
We wanted to talk about a topic that's been quite popular in the media recently: how you recover money when someone won't pay. When the law gives you leverage to push back, you need to know what to do. It gets to a point where negotiations come to a stalemate or just don't progress to anywhere, and so they'll give myself or yourself a call and work out what their options are. And what's been your experience when it comes to letters of demand and their utility?
Yeah, I tend to say to clients, look, the content of the letter of demand is not going to be anything that you probably can't come up with. And I think what tends to make a difference in a letter of demand coming from a lawyer as opposed to coming from the actual client themselves. Sometimes I say, it is the letterhead that adds the weight on the letter. And if anything, they are going to respond to a letter from a law firm as opposed to a letter from the actual creditor themselves. Is because, as you said rightly, they see that the creditor is taking things much more seriously. They are paying for a letter of demand, so they're willing to invest in recovering what's outstanding to them.
My experience is it's not about being aggressive. Contrary to popular belief, a lot of clients will come to you and say, I want you to be hard, I want you to be tough, I want you to be strong with them. And I say, look, that's okay. We can be aggressive, but we've got ethical obligations. And it's not really about being aggressive, it's about getting outcomes. And getting outcomes means being strategic, understanding the law, understanding the facts, applying them correctly. And I think that's what a good letter of demand does. So when I draft a letter of demand, I'll often look at asking the client to, permit us to do something a bit more detailed than just a standard letter. It's got to be persuasive. It's got to carry weight. It's got to have information in it that would make the recipient realise and understand that this is the best option. Accept this offer because the alternative is potentially going to be much more expensive. And that also may involve going to your own lawyer and having to ask them how to interpret it. So it's worthwhile investing at least in one letter of demand. I don't really recommend generally that the parties go around and around in circles and litigate the matter by correspondence. I think if you can do your best letter up front and it doesn't attract a positive response, then really you need to start looking at other options. And there was a recent case example where my client was suing a business owner, and I won't go into the details of it because they're private, but needless to say, the business owner owed our client about, I think it was around about, from memory, $93,000. So still within the magistrate's court range, because the magistrate's court's got the jurisdiction up to $100,000, and it's quite often a cheaper and much faster jurisdiction to litigate in if you can. We issued a letter of demand. In the letter of demand, we set out our client's case in detail, why our client had good prospects as sex and why they were going to likely lose the case. And at the end of the letter, we basically pointed out, well, here's our costs to date. Here's the sum of $93,000 that's required to be paid, and that if they're prepared to pay a negotiated amount of costs, and the $93,000 will forego any interest claim, and we won't bring the proceeding in the magistrate's court. And then ultimately, this business owner had probably been through this before, made the intelligent decision to accept the offer, and in fact, in that scenario, he offered to pay in instalments, but large instalments. It was about $10,000 a month, and we ultimately talked to our clients and said, look, if you take into account all the time and costs involved in litigating and what they're offering now, And yes, it's installments. It's a bit frustrating, but you're going to save yourself going to court. You're going to save yourself paying us excessive amounts of legal costs. You've got a really good outcome, and effectively you've got a settlement agreement. We entered into a settlement deed, so if they default on that, you can apply for judgment in the court anyway, and you can skip the whole litigation process fairly easily. So if a defendant is prepared to come to the table and make an offer that's reasonable, then quite often that those things can be accepted. But it's not going to be the same approach for every case. Every case is going to be treated on its merits, and that was just a particular situation involving a debt. But I thought I'd give you a case example. Have you had yourself, Rodrigo, any examples recently of dealing people involved in debt recovery matters, or just trying to recover money generally?
Yes. These examples or these sort of cases tend to come up more frequent than one would expect. Unfortunate reality is that there are people out there that carry out the services and they don't get paid, and then they come to me somewhat frustrated, saying, "But Rodrigo, I've done the work. I just want to be paid for what I've done. I just want what belongs to me. I don't want anything more." I've had an electrician recently. He carried out a job, and I think the invoice was roughly $50,000. And the construction industry at the moment is going through a tough time. And the homeowner knew to just ignore, and sometimes it is not until you get a lawyer involved drafting a letter of demand that then they start to engage in negotiations. And as you said, more often than not, they don't have the lump sum sitting in the bank account, but they are willing to entertain negotiations and enter into a payment plan, which arguably could have been put forward much earlier in the piece, but it's not until you exert a bit of pressure.
Push the button.
That's right. Yeah.
Push the button.
So, and I also think that letters of demand are a good way to protect our clients and also flesh out, which I think will bring us to our next point as to whether or not there are any genuine disputes in respect of the debt.
Well, that's a good point you make, Rodrigo, because the letter can be a good way to just open up the conversation and start the communication. And number two, it can be a good way to get a response. Sometimes there's no response. They're blocked. There's a wall. You're trying to get your money and there's a wall of silence for months or years, and it's a good way to prompt a response. Well, why aren't you paying this? Is there an issue with the invoice? Was there an issue with the services, the goods? Are you disputing the contract? Or what is the problem? Let's start talking about what exactly your case is, because you're going to have to put a defence on if we go to court anyway. So tell us your position now. Let's even have a without prejudice discussion confidentially. Let's work out exactly how we're going to resolve this. What is your problem? That's the sort of things that I'm thinking with letters of demand that can come out of it, because, it's only going to keep going. We've seen a 63% spike in insolvencies in Victoria in this past year alone, the highest in the country, and that's been well documented in the media. So that's a lot of unpaid invoices, failed contracts, personal guarantees. Could be landlord, supplier, contractor, in any industry, construction, retail, hospitality, you name it. So there's a lot of issues going on at the moment. I suspect, we've got things like statutory demands. If a debt's over $4,000, you can bring potentially a claim in the state or federal courts against a company to wind it up. It usually attracts a pretty quick prompt payment from a company because of the risk of their company being wound up, meaning that it will obviously ultimately be placed into the hands likely of a liquidator who will take control of the company and any assets to sell to pay the creditors. So have you got any experience recently with issuing any statutory demands?
Yeah, so at the moment, I'd say probably over the last 18 months, in terms of issuing statutory demands, I'm going through a period where I'm issuing, I'd say, 2 or 3 statutory demands per week. And I don't think this is a small amount where I'm not acting for a lender or anyone who has got a big debtor book. I ask for, small business owners that letters of demands have not been responded to, the work has been done, and they haven't been paid. and then in circumstances where no response is coming forthwith, I've got a client, as I always tell you, that they don't understand why they are not being paid and that there was nothing wrong with what they've done. And on the basis that there is no genuine dispute, I've got no other option but to assume that this company that is not paying my client is in financial strife, and so we shoot off the statutory demand. I've seen, sometimes they react, they get on to me early on, and they know that they have 21 days to reach an agreement before the statutory demand expires. Sometimes, the statutory demand expires and we proceed issuing the winding up application. And sometimes, the day before the hearing, they get on the phone and they want to pay. So it's just, sometimes they don't have the money as well. So it just, the reaction can be, or the results, can range, but I think there is no better way of finding out as to whether or not they have the money to pay than to issuing with a statutory demand sometimes.
Yeah, and I think the issue faced by the recipient is that they've committed an act of insolvency, effectively, putting it in layman's terms. They're in a worse position if they don't pay within the 21 days and, trying to negotiate after that, they lose quite a lot of leverage. And so the power sort of swings back to the person who's issued the statutory demand after that. And so this is also an important point. On the other hand, if someone comes to us who's received a statutory demand, because we obviously act for both sides, then, the advice would obviously be quite different. It might be, unless there's a defect with the statutory demand notice or there's a genuine dispute about the debt, unless there's some sort of defence available under the legislation, in particular to our client, then, quite often the client's really looking at having to pay that money or face the reality that they're going to lose their company, lose their business that's attached to the company. What do you think about that?
Yeah, and I think, it brings very serious consequences. So first of all, I tell clients, make sure that your registered office is up to date, okay? Because statutory demand goes out, but it goes to an old address. You say you've never received it. Well, tough luck, okay? So I think, first of all...
Great advice, by the way.
Yeah, so first of all, I think registered office, something so simple, okay? And I think
with ASIC, yeah? The registered offices with ASIC.
Yes. So, that's to start with. And then second of all, when at the time of advising clients in respect of the issuance of a statutory demand, they've done the right thing, they've carried out the works, no response is forthcoming. I think a statutory demand is a really good way to put the pressure on the other party. If they receive a statutory demand, they have to either pay, it either gets withdrawn by consent, or alternatively, it's whoever received the statutory demand, it's up to them to go off to the Supreme Court, make an application to have it set aside on an alleged genuine dispute. But, to make the application themselves, it will cost minimum $15,000. So then you really force the other side, or whoever owes the money, to really think, well, am I going to spend $15,000, make an application to the court to have an argument? Or am I better off engaging in negotiations and coming to an agreement?
Yeah, I like that approach, Rodrigo. I think it's really sensible. And we need more lawyers giving pragmatic, sensible advice. And I've got a very big focus on trying to minimise costs for anyone where it's possible. It's not always possible because the law is a complicated thing and the justice system is as well. So, but I know certainly where we can, we'll definitely encourage clients to minimise their costs and help themselves. And I know you probably take the same approach, don't you, Rodrigo?
Yeah, I do. And where do you draw the line as to whether you think it's worth pursuing through the courts, or where do you tell your client, you know what, just write it off and move on?
It's case by case. There's no real exact answer to that question. Some clients have the ability to fund a matter, some just don't. Some have a higher risk appetite, some just don't. And this is more of a personality thing. And it's also can come down to experience. Some people have got a lot of experience in the justice system and they know exactly how it can go pear-shaped, get very expensive. And so they might make a commercial decision based on their business acumen, especially when it comes to financial matters like just debts and recovering money. These cases shouldn't be fueled by emotion. You know, we're not talking about you're arguing over intellectual property rights that would destroy your business, or you're not arguing over potentially someone's valuable item that they're trying to recover, which is priceless antique that they got from their ancestors, or I'm giving strange examples, but there's some things that are worth litigating over, so you have no choice. Money is always optional, because if you have a job, you have a business, you can still make money. You can make more money in the future. So you need to think about the utility of engaging lawyers and what exactly you're going to get out of it. So when you talk to your lawyers, ask them to do the breakdown of the maths on it. You can do the maths. What is it going to cost you? What are you recovering? Is there any assets there? You could pay your lawyers to do some asset checks. You could do them yourself. There's a lot of checks you can do online. Skip tracing. Not everything is revealed. A lot of stuff's private, trusts and stuff, but there are some things you can check. And you then need to measure up, what is my risk appetite? What am I prepared to invest? What am I prepared to lose? So unless you've got anything else to say on that topic, I'll move to the next point, which is dealing with individuals, Rodrigo. You happy for me to move on?
Yeah, no problem. And I think individuals are completely different, I feel.
It is. We're talking about bankruptcy notices here. In different legislation, it's when a person owes you money. And at the moment, it's over $10,000 to issue a bankruptcy notice, but it changes, and it did change during COVID. And it's quite often the case that will also attract a positive response in payment if the person has money, from my experience, because effectively you'll have someone, a trustee in bankruptcy, come in and take control of your estate and affairs and sell things that you own to pay creditors, and no one wants that. Plus, it's also a black mark against your name, which will show up at least in public records for at least 10 years. And it'll be a period of years where I think it's 3 years at the moment, as far as I can recall from recently checking it. And we've also got to be mindful as well when it comes to legal matters that, you always got to check the legislation on the day you're advising a client, because the law is subject to change all the time. Federal Circuit and Family Court of Australia. For anyone that's listening, don't get confused. It's not the Family Court. The courts were separated and brought together a little while ago. So it's just effectively the Federal Circuit Court's the most common place that people will go. Effectively a bankruptcy notice is issued to try and compel an individual to pay or a debt or face bankruptcy. And the same time period, 21 days. So have you had any experience with any of that recently, Rodrigo?
Yes, and different from just simply issuing a statutory demand. You're unable to issue a bankruptcy notice unless you've got a judgment. In order to be able to get to the bankruptcy notice, you first need to issue a claim or a statement of claim or a writ in any of the courts. You then need to obtain a final judgment and order saying that an amount exceeding $10,000 is owed, which then enables you to issue a bankruptcy notice. So you can see the objective of the government and the seriousness that a bankruptcy notice can have, and why it is that they make it a little bit harder in order for a creditor to be able to issue a bankruptcy notice. And understandably, most people have real property in their names. That's their residential home, and bankruptcy can have catastrophic consequences where they end up ultimately losing their home. Having said that, because of the serious consequences that it can bring, again, it applies a lot of pressure on the individual who owes the money, and more often than not, if there is money there or if they got something to protect, they will come to the table and come to an agreement. And again, it goes back to the idea of getting a result for our clients.
And you could also potentially, without annoying the court, maybe carefully call up the registry and find out what the timeframes are on federal circuit versus federal. They are managed by different people. They've got different judges, and find out which one's quicker. Maybe.
No, I agree with you.
It's an option. If the client don't care about time or fees, you can go either. But generally, I'll go federal circuit court as my preference. So I had a recent example with a builder that was made subject to a final VCAT order, didn't pay the individual. He was made bankrupt, and he effectively was unable or didn't want to pay his debt, but he had a family home that he co-shared or co-owned with his wife, which we realised had actually been secured to some related party. So it then brings us to our next topic, which is about the powers of liquidators and trustees, and their ability to claw back funds. In this instance, we said to our client, well, the trustee in bankruptcy wants to be funded, wants to receive some money to do investigations and use their powers under the legislation under the Bankruptcy Act to try and work out what's going on here with the assets, with the bankrupt, the builder, and they were looking at all sorts of things, and they do have effectively a lot of powers. The main ones are unfair preferences, uncommercial transactions, insolvent trading. So for those out there that don't know what they mean, unfair preference is basically if one creditor was paid whilst others missed out, that payment may be clawed back, generally within 6 months before the liquidation. Or you've got uncommercial transactions, deals where value wasn't equal, e.g. giving away assets, selling it under value, and insolvent trading. Directors can be personally liable for the debts if they kept trading whilst insolvent. So different but similar processes and powers of liquidators and trustees to claw back assets in different scenarios. Depends on the facts, requires a close forensic analysis of the chronology of events and what happened, and it'll be similar sort of investigations that would be done by a trustee in a bankruptcy situation or a liquidator in relation to a company situation. Have you seen any situations or examples, Rodrigo, where through that process a liquidator or a trustee's been able to recover monies for the creditors?
Yes, I have. Specifically with unfair preferences, had invoices outstanding to them. They've exerted a bit of pressure. They've managed to get payment. A couple months later, the company goes into liquidation. So then you have the liquidator demanding the payment that was received by the creditor within the 6 months prior to the company going into liquidation. So it does happen more often that you would think. There are ways that one can protect themselves and prevent that from being able to take place, or at least making it harder for the liquidator.
I have seen directors repay tens of thousands of dollars after a liquidator could prove that the company was insolvent and still racked up debts, and where we've given the option to the client that they should fund a liquidator, at least to some degree, to try and do those investigations. A lot of the time clients are resistant to that because they've probably already spent money up to that point, but why get all the way to the end and not try? I usually say to clients, you never know what you're going to find, and they do have a lot of powers, and usually they uncover quite a lot of interesting things. There's a lot of very capable liquidators and trustees out there. They're very good in that area. They generally know what they're doing, and they will try to work in the best interests of the creditors. So never close the door. Always think that step might be a necessary step. I think we've given people a lot to think about today, Rodrigo, and I'd like to thank you very much for coming on.
No problem. Thanks for having me.
And I really appreciated your input today. It was invaluable. I just want to say to everyone out there watching, thank you very much. If you ever need any assistance, don't be scared, don't be shy, don't put it off. Feel free to reach out. We're here to help, and we're here to look after your best interests.